Hello, everyone, and welcome to One Civil Law, and I hope you're having a great day. And for today's coverage, we are continuing our coverage of the Karen Reed trial, which is currently underway, and we are having a motions hearing. Apparently, theoretically, we have a jury. I'm excited. You're excited. Opening arguments are currently scheduled for Tuesday. Today, we're supposed to have some motions hearing relating to outstanding motions. So we'll see how all that goes. It should be exciting and fun. And I am getting hyped for the Karen Reed trial, part 2, Electric Boogaloo, because part 1 was so much fun. Part 2, hopefully, will be just as much fun and frivolities as it was the first time. Hopefully, it will just be a laugh riot a minute, because that was basically what happened the first time around. And this time might be even more fun because, of course, our good friend, yours and mine, Trooper Proctor, unfortunately now is better known as Mr. Proctor, because he was kicked off the force, dishonorably discharged for, many problems that he did because he wasn't a very good person. I mean, personally, professionally, and in other ways. So our lead investigator credibility is even more in shambles than it was the first time. And of course, that's all going to be fun and exciting, I imagine. And we're going to have some hearings relating to all that stuff, plus whatever other outstanding motions currently are on the table. My understanding is that the ARCA experts have been allowed to testify. Not surprising. As I previously stated, they were sort of teeing up excluding them. But as I also stated, it would be a big decision. And so it's not surprising to me that Judge Bev decided not to go down that road, because if she had gone down that road, she is just begging the Court of Appeals to overturn her, because she better be sure, baby. She better be sure, because if that was a mistake, it's almost certainly a reversible error, right? That's like you got to get that one right. If you're wrong, you're just begging for trial number 3, assuming she's convicted. So, not surprising that we didn't exclude the ARCA experts after all, because I mean, there's already enough issues on the table, guys, with other things, right? There's already enough issues from the first trial, and undoubtedly the second trial, I'm sure, where we have potential reversible issues already on the table. So we don't really need to add to that pile by just giving like the biggest silver bullet ever. It's already sort of problematic enough as it is, right? If she's convicted, will she be reversed? I don't know. I do know that there's quite a few issues on the table that certainly have gotten my attention. But if they had excluded ARCA and she had gotten convicted, I'd be like, yeah, I'm pretty sure this is getting reversed, because you got to be right, and probably not so much, no. So, yeah, all that good stuff. So that is sort of where we're sitting at the moment, and we are just, of course, waiting for the trial to start. It's supposed to start at the top of the hour. I'm hyped. You're hyped. Everyone's hyped. It's great. And good morning to all of you. I hope you're just having the bestest of days. I'm having a reasonably positive day. I've had a haircut. I've brushed my teeth. Put a nice shirt. All that good stuff. So feeling reasonably positive. Good morning. Let's see who's here so far. Tony is here, of course. Unbalanced Equation is here. Glad to have you here. We're all mad here. Been a member for 6 months. Unbalanced Equation's been a member for 5 months. Thank you so much. Cardigans is here. Jules is here. Notorious. Johnny Osprey, Snacks. Geraldine Federich, I think. Jennifer C. Lynn Britton. Johnny Osprey. Carnigans, Kathy Pariseau. Pita, or Pita, maybe. Good morning. Sassy Vice, 420. Jim Tusser. Any thoughts on what I'll be doing Watch Assembly? Probably on Saturday. Will it be on stream? Yes. For all of its horrible, horrible glory, it will be on stream. You will get to enjoy, because I've never done it before. So it's going to be tedious, slow, and probably with a lot of handshaking. It's going to be a trash fire. But yes, I will stream it. And then, of course, the odds of me screwing it up and marking the dial or bending the hands or something like that, the odds of something going wrong are pretty high. So you can look forward to basically all those things in every dimension. It's going to be challenging and fun. And assuming we get it done, though, of course, any subsequent build will be less problematic. So it'll hopefully only be disaster fuel the first time. And if we do it again, then, obviously anything you do more than once, you'll get better at it. And hopefully eventually it will become fairly easy. But, you will get to watch me do it for the first time, and it will be just as horrible as you can imagine. I'd like to also welcome to the stream Lamp. Lamp is glowing for us today. Lamp is not exactly chandelier. Lamp is a chandelier in potentia. It hopes to be a chandelier someday, but it hasn't yet grown into being a chandelier. It's a baby chandelier, but it is still shining brightly if it is not having all of its augments. So we believe in baby chandelier. Baby chandelier will eventually become the grown-up chandelier we all know it can be, and we are all very excited for that. Jules says you cut 4 minutes off your 5K time. Excellent. That is promising. Very good. Yes, I also miss Fan. I miss Only Fan as well. Now we have Only Lamp. Only Lamp is, well, it's not my favorite starlet. What can I say? I have my tastes. You have yours. Don't shame me for my tastes. I won't shame you for yours. I much prefer the curves and shake of Lamp or of Fan. Lamp also, I feel, might be trying a little too hard with that gold accent. I feel like it's trying to show off a little bit. I think it's trying to peacock. But I guess again that can be written off to the youth issue. It thinks that being gold and gaudy is the way to attract the attention. But I feel like it's trying too hard. And maybe as it grows up, it will try something in a more subtle pattern. But we'll see. Bev is going to rule against anything that will help the defense, Jennifer says. That's a pretty reasonable bet, Jennifer. If you want to know how the judge is going to rule, just ask, will it help the defense or will it help the prosecution? And that's a pretty good metric for, which way she's likely to go. You think Lamp is more sophisticated than Fam? I think Lamp is trying to be more sophisticated than Fam. But I'm not sure it really is more sophisticated than Fam. I think Lamp is one of those people who wants to be part of the rich hoi polloi sort of crowd and is trying to dress to be part of them. Not only does Lamp not fully belong, but what Lamp doesn't realize yet is it doesn't really want to belong. It sees all these people, these hoity-toity people in their nice clothing and their nice cars, going to the country club and going to the yacht club and all the rest of it, in their elegance. And it thinks, I want to be part of that scene. And so it's trying to dress to be part of that scene, but it's really not part of that scene. And what it doesn't really realize yet is it doesn't want to be part of that scene. Those people are almost invariably fake and vapid and also unhappy. They're all putting on a show for each other. For what reason is unclear, but they're all basically trying to put on a show for each other, and it isn't really any of them. And to the extent it is them, they're not really good people anyway. So that's what I feel like Lamp is going for here. And I feel like Lamp is on the wrong path. I feel like Lamp would be happier. Lamp can be rich, but it doesn't necessarily have to hang out with that kind of crowd. You know what I mean? Just because you're rich doesn't mean you have to put on the tux and the fancy, elegant dinner gown and go to the fancy dinner place and, you know, with the waiters and the tablecloths and the napkins and, you know, everyone's a little pretentious and says, "Darling," you know, you don't have to hang out with those people. You know, especially if you're old money. Like the old money doesn't do that. Old money, you know, dresses much more humbly. Old money is not showy. Old money can just be in a t-shirt and jeans and driving a beat up Land Rover. I think that's the way to go, man. I think that's the way to go. You know, just look like a farmer and have $1 billion in the bank. It's a better path, my friends. I think. Just a personal opinion. Lamp is the Jen McCabe of chandeliers. Yeah, they're certainly heading in that direction. And also, unfortunately, Lamp doesn't have any other characters on screen. So I can't really like, although I see what looks like on the very edge of the screen, I see a brass thing, which might be another lamp. It's not clear what it is, but it might be another lamp over there on the right, just peeking out. So unclear if that's Lamp's friend. Is that Lamp's rival? Is it who Lamp looks up to? Is it who Lamp thinks they want to be someday? Is it who they're trying to be? I think Lamp just needs to be itself. I think Lamp is part of that, especially New England, hoi polloi, Richie Patootie kind of crowd. The kind of people that go to the Met Gallery. Those kind of people. The cameraman just zoomed in further on Lamp. I don't think they want us to see Lamp's friend, rival, or anything else. Or either that or cameraman is infatuated with Lamp and is lusting after Lamp. Thank you very much for the gift memberships, by the way. Thank you, Tracy Walker, for the 50 gift memberships. And then for another 50 gift memberships, that is extremely appreciated. Thank you for your kind donation. It is exceptionally appreciated. I'm a private dancer for money. Do what you want me to do. What kind of bulb do you think Lamp has? Probably an LED. What kind of LED do you think Lamp has? Is it really the kind of LED that Lamp really wants to have? I feel like Lamp might want like a tungsten light bulb, maybe, rather than like just a. I think, yeah, I think that's part of the problem. I think it's just got a very neutral colored LED. I think maybe Lamp would like a tungsten bulb better. Yeah. No way they change those lamps to fit LEDs. LEDs these days comes in many sizes, so they make an LED that will fit just about any lamp these days. So probably an LED. Thank you, Jennifer, for becoming a non-civilian. It is exceptionally appreciated. Thank you. I wish there were more things on screen because then I could ship it. What am I supposed to do? Ship lamp with the ceiling? I guess I could ship lamp and ceiling, but I mean, it's just not the same. I want to ship lamp with ceiling fan or other lamp or fire alarm or wall sconce. I don't really have anything to ship lamp with. Lame. I liked it better when we had lamp, seal, and chandelier. That was the best days when we were doing the Murdaugh trial in South Carolina, and we had lamp, chandelier, and seal, and we had a nice love triangle going on that I was developing with appearances also by sconce and other artifacts in the courtroom made appearances. It was a fantastic soap opera that we were developing. But I don't have anything to work with here. And then also later, we decided that chicken was the real murderer. And then we started talking about how the chicken was the real murderer for a while. And that was also fun. Only Lamp is on a journey of self-discovery. Yeah, I really feel like that's what's happening. I feel like Only Lamp is trying too hard. I feel like Only Lamp is hanging out with the crowd. Oh, wait, no, we're moving. Oh, wait, no, other lamp. Oh, no, fans back. Fans back. Fans back. Fans back. Fans back. Woo! Yeah, spin for me, baby. Spin. Spin for me, baby. Someone told the camera person that we like fan. Yeah. Give me fan, baby. Spin for me. Spin for me, you fan harlot. Yeah. This is great. Fantastic. Awesome. The spinning to victory, spinning to freedom, moving that air around, keeping the circulation of the room going, preventing it from becoming too stuffy. Fan checks us. Fan enthralls us. Fan cools us. Fan prevents the air from being too stuffy. Fan is practical. Fan is lovely. Fan is simple. Fan does not believe in gaudy. Fan is just as simple can be, man. Just white on white, man. This is a New England fan for sure. It is as white can be. That's how you know it's a New England fan. Super white. All the white. I think the fan might be from Vermont or maybe New Hampshire. It's so white. Not clear if it's necessarily a Massachusetts native fan because of how white it is. I think it comes from even newer New England is how white it is. Maybe Connecticut. Maybe, yeah, something like that. I don't think this is a Massachusetts fan, but it's in a Massachusetts courthouse right now. It has moved. It has moved trying to achieve its dreams, and I respect that. And it is here trying to cool the rest of the audience and show a singular dedication to purpose. It is reliable. It is dedicated. It works hard, despite the white. It works hard. It puts in its hours. It does a great job. Fan is fantastic, man. Fan is awesome. Excellent. Thank you, camera guy, for showing us Fan. Fan is happy. Fan is not trying too hard. Fan is exerting. Fan's effort is in its productivity. Fan is trying hard, but it's not try hard. It is what it is. It is Fan. It does Fan. It knows Fan. We love Fan. Fan over Lamp all day, every day. Not even close. Stingy says, so it doesn't have Lynn in its name? No. I'm your biggest fan. I'll follow you till you love me. Nice. Little Lady Gaga there. I'm your biggest fan. I follow you till you love me. Papa, paparazzi. Da 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 ba, ba, da, yeah, let's sing it. A young 1,000 points in your buck. Too much singing, you get a copyright strike. Man, I like Lady Gaga. You know, I really like the work she did with like Tony Bennett and stuff in particular. She's talented. Stephanie will always have a place in my heart. I also really like the fact that when she was back at school, you know, there was a Facebook group saying that she would never be amount to anything. I find that hilarious. There was a Facebook hater group. Stephanie Germanata will never amount to anything. Yeah, she kind of did though. So way to go on that one, guys. She's coming to Australia. That can be fun. She seems like someone that would be interesting to talk to. She strikes me as someone who probably is more intelligent than perhaps her persona might necessarily indicate, because she has a very flamboyant persona. But she strikes me as someone who is perhaps a little bit more reserved in her actual life than she represents on screen. It could be just me, but she strikes me as, when I see her like putting on the things she puts on, it strikes me as very much she's trying to put on a show that isn't necessarily 100% her. But yeah, maybe it's just me. Maybe I'm seeing something that isn't there, but I don't know. We are still in motions hearing. She tells you she can't read her poker face. Hmm. Trial is expected to start on Tuesday, is when we're expecting oral argument based on what we know right now. Is my camera big enough in the corner there, or do I need to be bigger than that? Probably is an okay size. I could also put myself off to the side and then have the camera like, I could also do it. Let me see if this way looks better. Hmm. Yeah, is that better or is that worse? I don't know if that's better or worse. Yeah, probably worse. I'm formatted under the chat on your TV because the chat, when it superimposes, goes on top of me. Interesting. So I need to like move my camera to the other side. Okay, hold on. I can do that. Yeah, there you go. How about that? Is that better? Try to get as many of these problems resolved before we actually get into the trial itself, you know? If I have chat on TV, the chat's off to the right of the screen. Okay, so I'll put me on the left then, and it'll be better. A green screen, I could do a green screen, but why? Like, I want to have the background. That's why I spent so much time on the background. So the background would be nice. I don't. Yeah, I mean, I have a green screen. I don't want to use a green screen though. I don't. Yeah, I just want you to see. Yeah, I want you to see my background distinctly. So yeah, I'm gonna boycott green screen idea, but I appreciate it anyway. I also spent time this morning trying to get the background exactly centered because it was slightly off. And I think that's about as close as it's going to be. Because like if you take a look at like where the metal is, right? You take a look at the further side of the bookcase and the other further side, right? The top of the bookcase is even, right? In both cases, the very top of the bookcase is touching the top of the screen. So that is about as level and about as centered as I think it can possibly be. But I did spend time this morning trying to make it this leveled and centered. I mean, that camera is about as bang in the middle as that can possibly be. But I did spend time this morning trying to make sure it was perfect just for you guys. I do care. Yeah, the window shining on the picture, that is a problem. You know, I need to either get the glass replaced so I get a less reflective glass or something. I probably should just take it to Michael's and just get the glass replaced. I think it's like $100 or $130 there or thereabouts to get the glass replaced with a glass that would not be as reflective. Incidentally, I did that with my YouTube button. So on the YouTube button, I coated that with plexiglass. I mean, you can't really tell probably, but I did think about it. Right. So I went to Michael's and I got a piece of plexiglass that was exactly the same size as the YouTube button because the plexiglass has a lot less reflective index than, you know, so I didn't want it to be as shiny. And I mean, you can still see the mirror of the YouTube itself, like because that has a mirror effect. So you can still see the mirror, but you don't get the shininess off the silver like you would. So I've already like done that for the silver YouTube button. Plus, it has the benefit of course, preserving the button because then it covers the button, so it isn't damaged and stuff. So I have done that in the past. So what I probably need to do is get the glass on the freedom of speech one replaced with the plexiglass so that it also would not be as shiny. I was actually looking into seeing if you could get a like a plastic cover for it, like an anti-reflective plastic cover, because you can get those for, you can get those sometimes for TVs or something, or you can get those for your like navigation system on your car. You can get a plastic thing that make it anti-reflective. I was looking into that, but some of those are like 50 or 60 bucks anyway. And so it's like, well, do I really want to spend 50 or 60 bucks on the plastic? Whereas I could just replace the entire glass for basically twice that, and it would be cleaner. So something to think about. Probably should replace it though, because yeah, it is a bit distracting with that reflectiveness. So I probably should just fix it. Yeah. Maybe I'll do it today. Maybe I'll go down to Michael's and I'll get it fixed. So it'll be nice for the trial. Anyone have 150 bucks? Or anyone know where I can get a anti-reflective film I could put over it that would be big enough to cover it? That would also solve my problem. So if anyone knows where I can get an anti-reflective film that is big enough for that piece of glass, let me know. I've looked previously on Amazon and stuff, but I wasn't able to find anything. I did find some stuff from some third-party companies that would sell pieces of anti-reflective plastic that were big enough for like a TV. But again, at that point, I was spending like 50 or 60 bucks anyway. And it's like, do I just want to spend 50 or 60 bucks on a piece of plastic, whereas I could just get the entire thing done maybe for twice or three times that? It's like, is it worth it for me just to F around with it? I don't know. Tracy Walker gives $200. Thank you very much, Tracy. I appreciate it. It's all nice. You got yours on Temu? All right, maybe I'll look at Temu. All right, thank you. I'll take a look at Temu and see if Temu can solve my problem. And thank you very much for the $200 from Tracy Walker. Home Depot carries anti-reflective film. Do they? Do they carry a film big enough? Let's find out. Because I've looked into this before and had problems finding something, but we can always look again because we're not doing anything. Let's spend some time seeing what we got. Oh yeah. All right, so that's fine. All right, let's see what we got. Anti-reflective window film or anti-reflective film. All right, hold on. Let's see what we got. Now we're looking for something that's clear, obviously, because we want you to be able to see it. So we're not looking for anything that has any tint on it. Privacy film, tinted heat film, privacy film. No. Yeah, I'm not seeing it. I'm not seeing clear matte film. Let's try clear matte and see if that helps. Clear matte film. Hold on, we'll figure this out together. All right, frosted film, heat control film, no. Masking, no. Heat control film, no. I'm not trying to control heat. I'm just trying to anti-reflect. No. Clear window protection film. Yeah. What is this? Oh, that's just like literally to protect it as you're moving it. That's not going to work. Nope. All right, that's not going to work. How about anti-glare film? Anti-glare film. Frosted film, gray glare control film, tinted heat control film, clear non-glare acrylic sheets. If it came in a bigger size, maybe, but 11 by 14 is not big enough, but at least it's heading in the right direction. Clear non-glare acrylic sheet, clear UV blocking film. You think the UV film will do what I need to do? Blocks 99% of UV rays, but that's not what I'm trying to do. Hold shattered glass, also not what I'm trying to do. Yeah, this doesn't say anything about anti-glare. This just blocks UV. If I was trying to block UV, this would be great, but that's not what I'm trying to do. So this will not work. Yeah, so and yeah, this isn't gonna work. All right, so yeah, none of those options seem to be viable. Only fan, by the way, is continuing to spin, by the way. Don't worry, you're not going to miss anything, I promise. Let's see if Temu has anything that works. Let's give Temu a shot. I've never used Temu before. This is going to be interesting. Anti-glare film. Mirror film, no. High definition automotive windshield reflective film. Car heads up display. I mean, that's the right idea. I just need it in a lot bigger size. I need a really big sheet of it. What if I did like TV anti-glare film? Because this thing is so big, it needs like anti-glare. Let's try anti-glare for a 55-inch TV screen. Blue light protector, polarized film sheets, 9 monitor anti-glare, scratch resistant. Okay, this sounds like maybe this is what I need. This is for a 27-inch, which is not big enough. Yeah. I'm not really seeing what I need. Not really seeing what I need. The Book of Light says, are you going to react to Donald Trump suggesting he'll deport U.S. states of American citizens? Well, I wasn't planning on doing a video about it, but it is incredibly, obviously illegal in every possible way. Put clear anti-glare film? Sure. Clear anti-glare film. Let's see what we got on clear anti-glare film. All right. Car window, heat blocking window privacy film, mirror anti-glare sunblocker, but I don't want to be mirrored. Mirrored is kind of like exactly what I'm trying to prevent. How can it be mirrored and anti-glare at the same time? How does that make sense? Those are like exactly opposite concepts. Privacy glass, anti-glare screen for a 15-inch laptop, one-way window film, UV blocking anti-glare. All right, maybe this is what I need. How about this? Is this what I want? All right, this is more promising. 4 milliliter one-way window film, classic mirror window tint, static cling, UV blocking, anti-glare privacy, and heat control. Okay. But in the daytime, in light, it's mirrored. So that does exactly what the opposite of what I need to do. I can't be mirrored because that's exactly what I'm trying to prevent. So the quest continues, guys. The quest continues, but I can't find exactly what it is I need, unfortunately. I know it's lame. I have tried to look into this before. How big does it need to be? That's a good question. How big does it need to be? Let's find out. It's been a while since I measured it. Where's my tape measure? How big does it need to be? Let's find out. $27.5. by 21 and a half. 27 and a half by 21 and a half is how big it needs to be. 27 and a half by 21 and a half. That's how big it needs to be. Looks 18 by 24. It's 27 and a half by 21 and a half. I literally just measured it. Would you like me to measure it again? The fan is great, yeah. Paralegal Liz is here. Hey, Paralegal Liz, how are you doing? Glad to see you here. Yeah. And now in terms of getting like a piece of plexiglass cut, Michaels will do it. I know they will. So that would solve my problem. This was what I was saying before. Like I can just take it down to Michaels. They can make a piece of plexiglass that big, and then it would be perfect. And it would solve my problem. They just replace the glass with plexiglass. The plexiglass is less reflective and it will work perfectly. So that's the easiest way to solve this problem. And then the cost of that's like, 100 or 150 bucks there or thereabouts. And, someone was kind enough to donate 200 bucks. So I can theoretically do it that way. And that would solve the problem. So, but, if there was an easier way to solve the problem, I'm down for it. But, I have looked before. As I said, I've looked before and I just can't find anything big enough that makes sense. But if you guys find anything that makes sense, feel free to drop it on the Discord. So if you can find a piece of anti-reflective, hopefully clearish would be nice. So clear, anti-reflective, non-mirrored, film. If you can find it, that's at least 27 and a half by 21 and a half. If you can find a piece of film that big, drop it on the Discord and let me know. And if that solves my problem, I will be happy to say that you were awesome and stuff in a community post. The court is still waiting to start. We are still dealing with OnlyFans. Thank you, by the way, for the 338 of you currently joining us. I appreciate you spending some time with us. You're not on Discord? Well, that problem is easy to solve, my friend. All you have to do is go to the link in my link tree. And incidentally, by the way, I need to create a command for Discord. So let me go ahead and do that. So you can just type * Discord and it will give you the link. Tony, would you be kind enough to give me the link in chat, or if you're here, so that I can just create a thing real fast for it, please? Or I can just pull it from my own link tree if Tony's not here. But Tony's always here, so I just expect him to always be here. What are we looking for? We're looking for a piece of anti-reflective, clear window film that's at least 27 and a half by 21 and a half is what we're looking for. That's what we're looking for. We're not trying to block UV. That's not what we're trying to do. So UV blocking is not necessary, and it is also not sufficient. If it happens to also block UV, I mean, that's fine that it also blocks UV, but that's not what we're trying to do. So, yeah. What am I missing here? I thought all my commands were in stream elements. Are they non-stream elements? Where are all my commands? I'm confused. Am I signed into like the wrong account? I might be signed to the wrong account. Hold on. YouTube. Okay, I'm signed into the wrong account. That's why. I think. No, this should be the right account. Okay, there it is. No idea how it works. Yeah, the Discord takes a little getting used to. But you'll figure it out. It's basically a persistent chat room, is what Discord is. Okay, yeah. So I need to, okay. All right, let's see. Join the Discord. Okay, copy this link. Great. All right. Now I need to add a new command. Okay, command is Discord. I'd like to say this. Join our Discord for, let's see, and keep the conversation going. Yeah, I think that makes sense. All right, activate command. All right, so now if I do this, yes, no, maybe. There it is. All right, great. So now we have a command for Discord. Excellent. So if someone ever asks about Discord again, you can just type exclamation Discord and it will give you the link for the Discord. Outstanding. So that solves that problem. I'm glad we were able to accomplish one thing today. Excellent. Back to the OnlyFam. Yeah, so only the Discord is a persistent chat room. It's a chat room that exists outside of YouTube so that people can chat persistently. It's also a great place to talk about things other than law. We have a channel for watches. We have a channel for talking about the gym. We have a channel for talking about food recipes. We have a channel for providing story suggestions, and so forth and so on. We have a room for talking about politics and religion if you're into that kind of thing. So we've got some rooms to talk about various topics, and then kind of general for everything else. And yeah, so it's a persistent chat room and allows people to talk about things. And it's the place also that I prefer that people send me stories they want me to talk about rather than sending them to me in email. So I prefer that people send me stories, or if they need to send me something, they send it to me on my Discord. You can send files on Discord. You know, you can send links, obviously. It's great. Can I show us cooking when it's done? Yeah, I mean, I always try to show you the meal when I'm done cooking. Also, talking about watches, I have found a new watch that I am very strongly looking at. And I would like to share with you this watch. It's on my community tab already, but we can talk about it more. This is by the brand Nomos. It's a German brand, Neomatic. This is 42 millimeter. It's got a color matched date wheel at 3 o'clock position. It's water resistant for 300 meters. Badass. And personally, I very much like the look of the small seconds at the 6 o'clock position. I think that's an old look with the 6 o'clock position seconds, but I like it. I think this dial is very clean. It's got like, you know, a sunburst kind of dial. It's reliable. It's from a nice brand. $2,000 used. I'm thinking about it. I'm thinking about it very hard. And then also in possible watches for that is completely different, we also have this big boy. We have this is the Zinn, also German. The Zen U1. This is 44 millimeter diver. This is 1,000 meter, just in case you need that extra 700 meters, just in case 300 meters wasn't enough. No problem. How about 1,000 meters? We got this big ass tool watch, 44 millimeter, big ass hands. Also approximately $2,000 used. I'm thinking about it. So we got this watch. We got this watch, and we also got this watch. Obviously, these are very different in watches. This one is more of a go anywhere, do anything watch. This watch is more, you could dress up, dress down. This watch would look fine with a suit. This one would look fine and everything. So this watch is a little bit more versatile. This watch is a statement. This watch is very much more brash and in your face. So which one do you guys like better? Do you like the Zen better? Or do you like, we'll have a little poll. Maybe we can do a poll and see which one you guys like. How do I create a poll? Hold on. All right. Which watch do you like best for $2,000? US. Do you like the Sin U1 or do you like the Nomos Neomatique better? And we'll take a little poll. So this is the Zen U1 and this is the Nomos Neomatique. Both made in Germany, both made by reliable brands. Both will last a lifetime. Both are excellent. Which one do you like better? I will take your suggestions at this time. Yes, your link did make it to Discord from a company called Texas Art. Exciting. Ooh, Texas even better. All right, let's see what we got from Texas Art. All right. Hold on. Yeah, all right. So, okay. We got these graphics acrylic film rolls. This high clarity general purpose film is perfect for many commercial art. This film is industry standard for overlays, color separations, layout. Available matte and clear, this acrylic is preferred when glare is a problem. Well, that is exactly my problem. That is exactly the problem I'm trying to solve. Okay. And then for 25 inches by 1,000 feet, I can get it for 86 bucks. Okay, so then I guess then the question is, do I buy it for 86 bucks? Because, well, then I get 100 feet of it, which is a shit ton. But then, I could use it for other things in the future, hypothetically. Also, can I just go buy this because it's Texas Art Supply? Can I just go to their store? Do they have a store? Where is their store? They do. They have stores in Houston, even better still. They have 2 stores in Houston. Outstanding. So maybe I'll go to Houston. Maybe I'll go to Texas Art Supply and I will get this film for 86 bucks. Well, it says list price is 115 and then your price is 86. I don't know what that means. I'm not paying more than 86 bucks for it. But maybe I'll just get this for 86 bucks. It's clear. And then I have more film for other projects in the future. That's probably the more logical way to go, isn't it? Just do that. Probably that's the more logical way to go. So Texas Art Supply may in fact be the solution to my problems. Thank you very much for the link suggestion. See, the Discord is already paying off. It is providing me the things I need to do stuff. Excellent. Excellent. I hope it helps. It looks like it will help as well. Thank you. Yeah, it will definitely be better and last better than a film. I mean, there's nothing that will do better than just replacing the glass. I mean, that will be the cleanest possible approach, right? I mean, obviously, it's the cleanest possible approach to just replace the glass. So, I mean, there is that factor. But, I probably will need to do anti-reflective stuff in the future. And so there is also that. Your uncle-in-law gave you a Tissot. Tissot makes some great stuff. Tissot's a fantastic brand. I really like the Tissot Gentleman a lot as a watch. It's a very clean watch. So yeah, Tissot makes some good stuff. Still spinning. What is the court waiting for? I don't know. We're just spinning. We're just spinning. I don't know what they're waiting for. They're an hour late, man. I don't know. That's all right. We're just going to hang out together, you and I. We're just chilling. I could use Rust-Oleum matte clear enamel coating. That feels a little janky. Yeah, I'm not really sure. I just want to use a spray. Yeah, if this were like a piece of wood, if it were outside or something, like maybe, right? So if I were trying to like hang a piece of wood or something outside, then yeah, sure, maybe I'd use the Rust-Oleum spray. I'm not really sure for indoor art purposes it's really the way to go, but I do appreciate your suggestion anyway. Yeah. I think that would be a suitable thing for many applications. I'm not sure it's suitable for this particular application. If I was trying to make my table outside less shiny, the Rust-Oleum might be the way to go. I don't think it's suitable for this purpose. Man. Is the hat new? No, it's the same hat I've had for years. It is the same hat. It might look a little different, but it is in fact the same hat. Maybe the color is changing. But no, it's the same hat I've had for 2 or 3 years, which is just as well because it was $850. So, you can't afford that, can't afford too many hats. But at least it's a very nice hat. Your hub wore the same watch from his dad. He gets new leather bands so often, goes to the battery store for lifetime replacements he paid for. That's funny. And then, of course, we're going to make watches pretty soon. That's exciting, too. I'm very excited about this. It's going to be interesting, challenging, and possibly a disaster. There's a significant probability. There's a significant probability that my attempt of making watches is going to go completely to shit. But we're going to give it a shot anyway. Because it sounds like fun. And if it all goes to hell, well, it only cost me like $100 for everything. So it wasn't that expensive of a try. Yeah. You've been a fan of self-winding watches instead of battery. Yeah. I mean, I understand that. Right. I like the solar watches, of course, as well. The watch I've been wearing every day right now is, of course, this wonderful watch. This is the Citizen ProMaster Tough Ray Mears that I've taken many photos of and shared with you before. Let me put it full screen so you can see it better. But this is solar. So you don't ever have to change the battery because, it's solar. Eventually, you'll have to replace the capacitor. But that's going to take like 15 or 20 years before the capacitor goes bad. At which point, by the way, you're probably better off just throwing the watch away, to be honest. I mean, the watch was $400. And to repair it probably is not worth it at that point. But you could. But so for 15 or 20 years, you never have to change the battery. And it will just work forever. And the Citizen is so good about this in terms of their solar and how they do power management. that this watch will run for 6 months in the dark. So it doesn't take very much light to make it work, because it'll run for 6 months in darkness, which is hilarious. Plus, it's sapphire crystal, 200-meter water resistant. It's a monoblock titanium, so it's very light. It's incredibly durable. It's a great watch to just beat the shit out of, because, and it's $400, which is, a lot of value for money. For a titanium with sapphire crystal, that's a very good deal. That's a lot of watch for $400. Plus, of course, being quartz, it's inherently accurate because it's quartz. So it's accurate to, plus or minus 15 seconds a month at the outside, So it's, yeah. So great. I wish you could wear a watch. Just Rhonda, I guarantee you there's a watch for you. I promise you that there's a watch for you. And if you're like one of these people who believes that there's not a watch for you because watches don't work, get a G-Shock. If you managed to kill a G-Shock, you were trying. You were trying. I'm just saying, man. I'll buy you a G-Shock. It will never die. You have to replace the battery like every 10 years. But it will never die. It's bulletproof. It's everything proof. You get yourself a G-Shock Solar and you don't even have to replace the battery. Well, yeah, we'll find you a watch that works for you, I promise. Spinny fan is all that's happening. Who makes the best wallets? Oh, I don't know. I mean, there's a lot of companies that make wallets. The wallet I have right now is just something that I got so that I could put an Apple AirTag in it because I was afraid of losing my wallet. Yeah. Maintenance free watch sounds fantastic. Yeah, you want a G-Shock, Rhonda. We're gonna find Rhonda a watch. We're gonna find Rhonda a watch. Let's take a look and see what we got for Rhonda. All right, so we're gonna get you a nice baby G. Let's see. All right, we're gonna get you a nice baby G, and we want you to get something that is solar would be nice. Let's see what we can find you. And it's only going to cost you $100 too. So all that. All right. Let's see. How about this one from Amazon? All right, here you go. Here you go. How about this for $130? The baby G. Oh, it's also a multi-band 6, so it automatically sets itself too. So it automatically sets itself if you're inside the United States, Japan, China, or continental Europe. It automatically sets itself every single day. So the time is perfect every single day because it sets itself to the atomic clock. So you're going to have the exact time all the time. It's solar. It's 200-meter water resistant for $130. So that does a lot. So there's a choice for you. That's the BGR-303U-7AJF ladies in white. But there you go. That watch will never ever die. It is the watch. It could be the watch for you. It's resin, so it's not even metal. So if you have metal allergies, you don't have to worry about it. It's resin. Let's see what else we can do for Rhonda. Let's see if we can find herself a square. That would be good. Oh, here's another one. Okay, we could do this. This is perhaps a little bit more your style. This is a little bit more expensive. This looks like it's about 150 bucks, give or take, depending on where we buy it. But here's another one. You could get yourself a nice square baby G. Same thing, multi-band solar, 200-meter water resistant. So you could do that. How about this one? This one's even cleaner. So you can do it with positive colors. Let's get you, come on, load the damn page. There you go. How about this one? This one in baby G. I don't think this one is solar though, and it's not multi-band, but it's clean. This is $91. You know, take a look at some of the baby G solars. It's the watch for you, Rhonda, I'm sure. And if it dies, let me know. Because if it dies, you went out of your way. They're legendarily reliable. They're impossible to kill. And then also, if you're worried about cracking the face of it, you can also get yourself some bull bars, like I had on my other G-Shock. You get yourself some little bars to protect the face of it, so you don't even have to worry about breaking the face of it. You get yourself some bull bars for like 20 bucks aftermarket. Easy peasy. Easy peasy. So yeah, do that. Do that. We're yeah. The straps are washable, all that too. Yeah. Yeah, no metal. Yeah, it's resin. Don't worry about it. Yeah, it's resin. You're great. Yeah, so we're here to help, Rhonda. You could also just get the bigger G. I don't know if it's too big for you, but you could always just get like the G. You could get the watch I have, the 5610. You know, which would be fine as well. It's a little bit cleaner in style, I think. Maybe it's a little big for you depending on your wrist size. So you might want something a little smaller, which is why I was looking at the baby G's, because they were a little bit smaller. But depending on your wrist size, and also the 5610 runs a little smaller than you expect. So you could just do that. So if it's not too big for your wrist size, then the one I would recommend would be the one I have, because I think it's awesome. So if it's not too big for your wrist size, then this one would be the one to get. This is the GWM 5610. This is a men's watch. I think it is 40, I want to say 43 or 44 millimeter, but it wears a little smaller than that, to be honest. This one's $100 right now on Amazon. It's on sale for $102. Yeah, but then again, this is multi-band solar, all resin, easy peasy. And it has a stopwatch, it has a timer, it has alarms, it has everything. It sets itself. What's not to love, right? All that good stuff. Oh, what happened? There's things happening, but I have no audio. Hold on. What's going on? What the fuck? I can't hear any noise. What's the fuck? What's going on? What's up? What's up? Oh, no, there's no sound. It's not just me. Oh, there's no sound. Oh, okay, fuck. Whew. Okay, it was just not me. Okay, I'm gonna breathe deeper now. I'm sorry. Oof. All right, so there's no sound. So we're just gonna look at miming. All right, that's fine. I'm gonna tell you what they're saying. Hi, my name is the prosecutor. I'm a total dickbag. I'm a tool. I'm a tool in every way, and I like being a tool. And I also like to, basically be a dickbag about everything and be kind of a jackass. I like talking, and I like talking with my little nasally ass voice and being a dickwad. Those are things I enjoy in my day. Oh, okay, so he's done talking. That was nice. There's sound on Andrea's stream, so she has a different feed somewhere. So it's just long crime. Long crime doesn't have, it's just long crime that doesn't have audio. Unfucking believable. Fine, no problem. Hold on. God damn it, long crime. No, channel 5 doesn't have audio. Does Core TV have audio?
I don't want you talking to
Core TV has audio. Fine, we'll go to Core TV. Holy shit. All right, fine. No problem.
Yay. All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good
Reed.
morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Good morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed. All right, so I appreciate getting those lists on what we all thought were still either under advisement or needed to be heard today. There's one that it seemed that, all right, we'll start, first of all, let's start with the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion for a forensically sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was that filed? That was filed a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion of its February 18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning, the Commonwealth went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata and available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial. I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information, and so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video, in this case, onto the detective drive at issue. So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that that be properly imaged for our review.
Okay, thank you, Mr. Brennan.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed, and then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing, it's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file? Because we've been in our request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question to me. Answer it, Mr. Brennan.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case, and it would then intrude upon private information and other investigations. They can go to the detective file and they can download everything to do with this case, but they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view. She can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol. I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors and the Commonwealth was separated from the jurors. But just be there and able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors. We need defense counsel. One defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide,
They want it, right? You want the vehicle there at the time?
We do.
if they want it there, then I'll be agreeable.
Okay.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see Counsel Tybar about this anyway?
I find it mildly hilarious that we're literally down to how are we getting there? Are we taking one bus or two? I find that just mildly humorous. It's like we're reduced to this. How are we getting down there? I don't know. Uber? I don't know. It's like it just strikes me as funny. You got to find the humor in things, man.
Have the new report of Lieutenant Wing.
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits.
All right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that appear on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr. Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan is going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the agreement? What's the agreement?
The agreement is there's going to be a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is, okay?
I will do that.
All right, thank you.
Thank you, Your Honor.
Okay. So, Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report, so that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial is upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I see no training on his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer. It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications.
Ooh, voir dire.
Before he's presented as a witness, so the court can determine whether or not he is in fact even a qualified witness in this case.
We need a drinking game, and voir dire should be on the drinking game. Drink.
Thank you, Your Honor.
Or a bingo card or something.
With regard to the report,
We definitely need to have a Karen Rain bingo card. We need to have some Karen Rain bingo cards. Maybe that can be something for the Discord. I like this idea more and more. All right, so on the Discord, we're going to try to create some bingo cards. So I need some items for the bingo cards. Red Solo Cup can be on the bingo card. Voir dire can be on the bingo card. Leaf blower can be on the bingo card. We need some things on the bingo card, and then we can have bingo cards and we can play bingo. It's going to be fun.
I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay. So why don't you provide me
And
with...
maybe we could give out a prize. We could have a prize a day. If we can get enough things on the bingo card so each bingo card is distinct, maybe we can find some sort of website that would allow these bingo cards to be randomized. And then people could sign up for a bingo card, and maybe the first person to get bingo every day gets some kind of prize. Could be good. I don't know what that would necessarily be, but maybe we could do something along those lines. So if you want to explore this idea, we're going to do it on the Discord and see if we can make this idea work. Could be fun. Or maybe like everyone who wins the bingo card, maybe they all get into one big drawing for a prize at the end. So if you win the bingo card each day, then you get an entry into a thing for a prize. Maybe it could be that. I don't know, something to look into.
The new or redacted one as well, and I'll take a look at it.
Right, that has, I will do that, Your Honor. I'll provide the court with that forthwith. The second is on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience, because it would take a lot of time to go through it, for several years he's been one of, if not the country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites two specific studies for his report, including pattern recognition, and the whole topic of pattern recognition was well established through Dr. Russell, so Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans, and we did make a motion for reconsideration with regard to Dr. Crosby, and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a sur rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with the wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court believes that, notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say I am not going to get in
The mold of Chloe, which is done with humans routinely.
That could have come from
hearing on, at a minimum, wait for that determination until the court reads the report
Right.
of Lieutenant Wing.
Right.
Thank you, Your Honor.
Okay. All right, so there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding reconsideration, I've found that he is an expert. I am not going to reconsider whether or not Dr. Crosby is an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog. I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify that this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Science was an extraordinary study, well-respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar, so it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds. That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth. In particular, Dr. Russell had opined not only that the bites were consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
Yeah, I have doubts on basically every part of that, to be honest. I'm not quite sure that you can do that in principle. And I also have doubts that they are molds of Chloe. They say that they're molds of Chloe, but I don't believe them. I demand proof of life. I want to see Chloe with a copy of USA Today. I want Chloe to be brought into the court. I need Chloe to be positively identified. You're telling me Chloe's alive? Bullshit. I demand proof, man. Bring Chloe into court. Yeah. We'll put Chloe on the stand. So I have questions about this on every level, to be honest. I'm not sure about any of that, but okay. Also, by the way, of course, a dog bite is going to be a dynamic incident. So you're talking about the dog moving and also the person moving. So I don't know necessarily that you can say, maybe you can, but it strikes me as a bit odd that you can say, well, like their teeth are this far apart, but the marks are only this far apart, therefore it's not the same dog. It's like, well, I don't know if that's necessarily true because the dog is moving and the person's moving. So I'm not necessarily sure that where their teeth are in their mouth necessarily would line up with where they are on the skin, because the skin stretches and all the rest and so forth and so on. So I have doubts that you're able to do what he says that you're able to do. Maybe you can, but I question it. So I've and then also further, I also have doubts on top of it that even if you could do it in principle, I have doubts that this guy is qualified to do it. because this guy is a dog behaviorist expert. He's an expert in how dogs behave. He's not expert in dog dentistry or dentistry in general, or he doesn't seem to have the qualifications to be able to draw these conclusions. So I question that you can do it in principle. I question this guy can do it. And also I question that it's really Chloe. I question basically multiple parts of this.
It's an uphill battle for you, I'll tell you that. I'll hear from Mr. Lewis.
Chloe also needs to go on the bingo card.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is referring to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard to the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Yeah, I mean, that sounds right to me. I mean, yeah, the National Academy of Sciences, which is as close to the gold standard for science as it gets, kind of, not to say that they're infallible, but they're, basically the best. So when the National Academy of Science speaks, we pay with a special attention. So the National Academy of Sciences, a number of years ago, 2009, he says, that sounds right, basically said that you can't do the dental impression thing anymore because it's basically junk science. This used to be a thing, right? They used to say, oh, the bite marks of the human being or whatever match this on this person. And the NAS is like, bullshit. You can't do it. You can't get down to the individual, right? You can't do it. It's bullshit. The science is bullshit. And so the science doesn't allow for the inclusion. I'm not sure it allows for exclusion of the individual either. I think his characterization of the NAS study is correct based on my memory. So that sounds right to me based on what I remember. So yeah, I don't think you can do individual inclusion or exclusion based on dental impressions. No.
Did you want to reply?
I would simply suggest that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate...
Well, that's kind of the wrong argument because that's the other way around. You're the one who wants to proffer the evidence. You're the one that needs to show it's sufficiently scientifically reliable. No matter what standard you use, different people have different standards, but like, it doesn't really matter if you use Daubert, doesn't really matter if you use the other one that I can't quite remember the name off the top of my head. It's like, it basically, it all boils down to sufficient reliability if you want to like look at it from the overarching viewpoint. So like, why is this sufficiently reliable in the scientific community? So you're not aware of any authority that excludes it. Yeah, you kind of need to, the other way around. The presumption, such as it is for exclusion. You need to show that it has sufficient basis in science to include it. So no, that's the wrong way to go about this.
I know it's a side matter. The idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right, thank you.
Yeah, that sounds like the wrong legal ruling to me. Right? If you want to say it's not a dog bite wound, okay, but still I still don't know that this guy's qualified to do it. So, yeah, you can't say it wasn't this dog. If you want to say it wasn't any dog, maybe something about it is inconsistent with any dog. Maybe you could do that. But even if you could do it, I still don't think this guy could do it. So I'm still off with no. This guy is not, no. But Bev's going to allow it because Bev doesn't understand things or something. I don't know.
Substitute chemist. Is there any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay, so Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar regarding, it's the Commonwealth 669 and Defense 670, I believe. It's about the audio-visual aids and giving notice. So you're both in agreement to give notice to the other side before you use anything, and have you done so with regard to openings?
The Commonwealth agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's going
Your
on?
Honor, we're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right, I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it up there.
That really is the
This is
motion.
for the court. The Commonwealth will provide a copy to defense. That's
Okay, thank you. Can I have the defense what you intend to put up?
This single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you.
I don't think I'm really a fan of allowing video or audio into opening. Yeah, I don't know. I'd have to think about it if I ever became a judge, whether I would allow it at all, to be honest. I mean, in opening, it's just to tell the story. It's just to set the story. It's like, do you need to actually bring evidence into this? Yeah, I'm not sure I would allow it as a judge. But I don't know. I'd have to think about it. But I don't think I like it. Old school, I guess.
So I need the defense to look at this before the end of the hearing, because I don't want to bring everybody back tomorrow if you object to what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's been an ongoing process. I understand my office has sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of
And
them.
if I ever become a judge, I'm going to think very, very seriously about banning any sort of Zoom appearance for any reason. Guys, we had court for several hundred years without Zoom. It was fine. We don't need to bring Zoom into this. It just makes everything worse. The quality is bad. Everything about it is bad. And it's just not the same as being there in person. You guys know this. Being a Zoom meeting is not the same as being in the room. It's just not the same. And the jury should have the ability to observe the person in the flesh. It's just not the same. If I ever become a judge, I am very, very, very strongly considering banning any video appearance for any reason. I'm really sorry your preferred witness is out of state and or has difficulty traveling and or whatever, but I just can't be bothered to care. We had courts without Zoom for hundreds and hundreds of years. Figure it out. Mic drop.
Unless there's a rebuttal portion, but I want to narrow down what we've given them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for.
I think that's what they just said. They're just going to
Yes,
give
we'll
you.
give them the file name and if the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection, or I can bring you all back tomorrow or Friday, and I don't really want to do that to you, so.
Thank you.
All right, so we'll just take a look at that. Okay, so that sort of also covers, I guess, the Commonwealth's motion regarding the use of extrajudicial statements, and if you hang on while I grab that. Is there an objection to that motion?
No, Your Honor.
Okay,
Can I make a note?
yes, please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation
Okay.
of text messages, but I think an independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right, how are you going to find this person?
But we could have somebody plain clothes from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if we have an independent reader who's available throughout the trial to play that role.
Okay,
May I have a moment, Your Honor?
yes.
So they want to read testimony into the record, and so they need someone to do that. So, I mean, fair. I'm not wearing a wig. Absolutely not. No. I'm not doing that. No wig. No. We don't do that in America. This is America. And at that, it's Texas. No. But it should be really good for the Zoom, right? I mean, it'll be really good if I wear the hat because people will watch my trials more.
My colleagues, I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations are intended to be independently read. At the last trial, they simply came in through the person that found the text messages. Mr. Lally asked, I think, Mr. Garino, I can't remember his first name, Mr. Garino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really weigh in.
Go ahead.
May I?
Yes.
Wherever there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Garino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would disagree gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Garino is the one who found it, he's a state trooper, he found the text messages, he was the one who downloaded the data, he was asked about those text messages previously. I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state, he can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're statement of a party opponent, and the other is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
All right. If I were to allow an independent reader, do you have a male and a female? Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
And that's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages as they were written and drafted, not the inflections and the repartee between two independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation.
If they're talking about doing independent, if they're talking about having a reader to read text messages in, I don't understand that. I thought they were talking about prior testimony. That would make more sense. If they're talking about text messages and having someone read them, that doesn't make sense. Yeah, you just do what you normally do. You get the witness on the stand. It's usually the police officer. You know, you ask the police officer and you have them read it. That's normally how you do it. You don't have a independent reader to read it as a dialogue. That's not how that's done. Yeah, that doesn't make sense. I don't understand that.
With someone, for instance, telephonically or verbally. People talk about it all the time. Things get lost in text messages. Having them read by a state trooper who found them.
So it can be perhaps, not a state trooper. That's all. I understood it to be to take out all infliction and completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly objectionable. And then once it's done, it's done.
All right. I will consider it.
I bet you will.
Thank you. All right, defendant's motion for specific discovery, paper 638, Jimmy. All right, who's up?
I don't understand why they're trying to reinvent the wheel. This doesn't make sense. Yeah, normally you just have the detective who discovered the messages read them if you need them read, and you just go from there. So why do we need to reinvent the wheel? I'm confused.
Arguing it?
Yes, that's me, Judge. Good morning. Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are 3 and 4, which are related. I will say, as a preface, that we are withdrawing request number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5? Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable, it's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests which extend beyond Rule 14, I am more than happy to give them. But I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right. The ARCA witnesses.
Are we still
Motions
doing?
regarding that.
Are we still doing ARCA?
So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
Are we still doing the ARCA witness thing? I thought this issue had been resolved. Has this issue not been resolved? Are we still talking about the ARCA witnesses? Holy shit.
There are 2 issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production.
I bet.
And then secondly, there is the limitations that should be imposed upon ARCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part, and that is we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCA that would make clear the relationship between the ARCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense.
Really?
That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, they will not have with them documents and other items which are necessary for the Commonwealth's review and likely use during the examination. And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the court to order ARCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024. The response by the defense, a large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant. So if the defense position is not in their custody and control, then I ask the court to order the ARCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly, the defense has provided that they have retained the ARCA witnesses independently. We have received no new discovery. other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCA witnesses potentially rebutting or commenting on Mr. Welch's testimony. Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again for a limited purpose, to order ARCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
Okay, who's arguing this?
I will not.
Okay.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new notices of discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate thereto. And insofar as, or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but we...
What do you think a timely manner is? What ballpark are you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day that we get them. In other words, I can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once I get it, we'll turn it over. So that's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith. With regard to docket number 642, we did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but...
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed, so this is not unusual. A party says, we asked for all 13, another party says, we gave them to you, and then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody or control.
So for which ones? Which of your numbers?
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously...
129/79. Blood pressure's looking good right now.
Would hope to have...
You're right, who knew?
That is the very point, that this is not responsive. Their discovery deadline has passed. And so I would like to talk about, or respond after Attorney Jackson is done, about what is going to evolve from this conversation. This is exactly what I was worried about back in November, what I expected might happen and should not have happened. So it's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all of the communications, all the text messages, all the emails between the parties. And if the defense's position is not in their custody and control, well, it's certainly in the custody and control of ARCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know who was what part of this report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr.
The
Jackson.
number one issue that Mr. Brennan has anticipated and tried to prevent is ARCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced and can be found in the ARCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, et cetera. They have everything. We've already turned that over. There is nothing that we have not turned over that's in our possession. With regard to the new information that Mr. Brennan says, this is exactly what I was worried about, et cetera, we could not engage these experts until we got permission from the Department of Justice. The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately, Your Honor, as best we could, leapt into action to contact ARCA and engage them formally so that they could act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have additional reports or findings as yet because it's only been a few days. If we get those, we will turn those over immediately. And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that if the court's satisfied with...
I have a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation, things that are normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rentschler talked about what he did, which was more on the biological side.
There was a difference between the two.
And Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it. and it's exactly what they testified to both in the voir dire and in the trial. There's no clarification, that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well. But
Is there anything that they're going to say they cannot provide because of the federal investigation?
not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
I can't believe we're still having this ARCA fight. I really can't.
That was the point. Right. Ms. Liu I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that's on the
Can they
table.
testify under what direction they did these things?
Well, they can certainly testify to what they did, absolutely. That is on the table. Every bit of testing, every bit of analysis
But
that
why
they
they did it?
What their communications were, what their directives were, that is confidential. And
Can I see Counsel at sidebar?
Oh my God. Really? We're still doing this. She's still teeing up excluding ARCA. Unfucking believable. I thought this issue was resolved. She's still teeing it up. I thought you guys said it was resolved. You guys lied to me in chat. One of you guys lied to me. You guys said that this issue was disposed of. It's not disposed of. She's still teeing up excluding ARCA. Unbelievable. I thought we resolved this issue a long time ago. How much have I lost in terms of weight? About 60 pounds, give or take. I was up a little bit this morning. So maybe this morning it's more like 57 pounds. But yeah, I'm down about something in that range. I'm still hovering in the 130s. I was up to like 135 this morning. I wasn't really happy. I want to go under 130, or apologize, not 135. That'd be amazing. 335. Yeah, but I'm still in the 330s. But yeah, I'm down like about 60 pounds. So promises, things are being made. Yeah, 130s. Yeah, if I was in the 130s, that'd be yeah, that'd be problematic. Yeah, 330. Yeah. Is this the actual trial? No, opening argument is on Tuesday. Yeah, 130. You should be worried. That'd be very underweight for my height. Yeah, that'd be grossly underweight for my height at 130s. Yeah, yeah. But apparently my blood pressure is good at the moment too, which is nice. Yeah, I'm 6 foot. Yeah. Yeah, I thought I was going metric. Yeah, no. We'll measure it in stone, so it doesn't sound so bad. But I need to lose another 100 pounds at least. And then we'll kind of see where we're at. My working goal right now is 220. So I need to lose another 100 pounds. And then we'll reevaluate once we get there. Yeah. Yeah, I don't like all caps. It's yelling. All the clothes shopping, I'm not worried about the clothes shopping. If I lose enough weight, I can just go to a thrift store and, buy clothing. Because they'll have stuff that will fit me. ARCA is a professional engineering company that does a lot of investigations. They did the Challenger investigation. They're pretty good. So yeah, they're pretty good. Are you going to talk to your doctor about the meds you're using? I don't think he'll be use it due to thyroid stuff. Yeah, I mean, obviously you have to find medication that works for you, and just because it works for me doesn't necessarily mean it will work for you. But hopefully you can find something. Yeah, the state's very desperate to get rid of defense experts. I mean, any constraint on their testimony and up to and including kicking them out is a really big deal. You're just inviting grounds of appeal at that point, because it's such a huge deal to exclude the ARCA experts. So any sort of limitation that Bev puts on them, and heaven forbid she kicks them out, you're looking at appeal, because you have to really justify that choice, man. It's not like it's an automatic reversal, but it's a big boy deal. It is a big boy deal. So, yeah. They, in fact, do not collect evidence in solo cups. This is very true. Yes. We could go back to looking at watches. That was fun. You guys overwhelmingly voted for the Nomos, which isn't surprising. It's a much more versatile watch for every day. They don't use low flowers either. Thank you for the 382 of you who are currently here. Thank you for tuning in with me here on Uncivil Law. Try to provide you some excellent legal commentary and some interesting thoughts. This case is effed up in so many ways. There are so many problems in this case. The judge's rulings are undefensible in a lot of ways. Sure. The problem, of course, as I said before, is not that she's necessarily holding the defense witnesses to the standard. The problem is she's not doing it evenly, right? That's the problem. Like, she's being incredibly anal and incredibly, exacting with the defense witnesses. That wouldn't be such a problem in and of itself if she was doing it to the state too, but she's not. The state can basically do no wrong and the defense can do no right. She wants the defense to mind their P's and Q's and, dot every I. But she doesn't really care if the prosecution does it. That's the problem. And we've seen that in the way she treats the witnesses. We've seen in the way that she treated the doctor who wanted to testify before with a voir dire. This emergency room doctor who wanted to testify. It's like, I've got 30 years of experience in the ER. I've seen a lot of dog bite wounds. I'd like to talk about it. And it's like, I'm not so sure about that expert. But then we turn around with the dog behavioral expert by the prosecution. Like, that sounds fine to me. He's qualified. Like, how's that work? It doesn't work. With the ARCA experts, I want to know everything they're going to say. I want to know every dot and tittle. Whereas, with the state's witnesses, like, their report's a little, it's like, it's like not a big deal. If she were consistent, it would be annoying, but not necessarily a problem. But she's not consistent. And so we are where we are. You got a smartwatch? Yeah, I don't want a smartwatch. I have no interest in a smartwatch. I have no interest in charging it every day. That's a pain in the ass. All right, Judge Bev, disappoint us.
All right, so, Mr. Jackson, you're saying that the ARCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct. That's what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data that they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct. That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the days. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery that ARCA does not list were not provided to them?
Correct. That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was provided.
All right, so when did you do?
We provided to them.
When did you do that?
I want to say March 26th or 27th. I think it's in the motion. Just take a quick look.
Okay.
Additional discovery for the experts for their review on March 26, 2025. Okay. That same day, the defense was provided all the additional materials to ARCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, et cetera. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
All right.
We are acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCA on March 26th.
All right, Mr. Brennan, I'll hear you.
I bet. All right, Mr. Brennan, you want to whine some more?
This is the very issue I've been concerned about since the beginning of this case.
I
And
bet.
I've made every effort to alert the court that I had a concern, in fact, that I anticipated this very thing would happen. When I began this case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to preclude ARCA from testifying, never.
Bullshit.
But
No,
it was to preclude the defense
that's some bullshit. I read it in your motions where you said you wanted to exclude ARCA. That's a lie.
from trying this case by ambush. And it was my primary concern, and that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention, notices anticipating, things that are not routine because I knew this very thing would happen. We had ARCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCA. That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCA has if you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that. The ARCA witnesses provide a report does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare, it creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCA witnesses. They've had 3 years. They could have retained any accident reconstructions they wanted, but they waited. They moved with a TUI letter on February 7, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders.
Did you now?
We provided
Really?
discovery
Did you?
pursuant to the orders, so
Are
that
you
they
sure?
would be held to the same standard.
I don't think so.
And now we hear they waited until February 7th, 2025 for a tour request. And now they're giving new information to ARCA to come back and potentially give new opinions that we have no ability for our experts to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration. This is a continued pattern from the last trial. They have their ARCA witnesses, they have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go back and reconsider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice, this isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to do.
Your Honor, what appears to be feigned indignation is just not consistent with the facts.
You tell him.
We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st, 2025, and we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled
Who needs facts,
that
man?
we could even use ARCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the Commonwealth disclosed in February of 2025. By mid-March, we asked for a TUI request. We asked for a TUI permission, or asked permission to engage them through a TUI request. That does take time. We did it expeditiously. We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day, engaged them, and immediately that same day, provided the Commonwealth notice that we had engaged them, and we intend to use them to, at the very least, to address Judd Welcher's testimony, or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discoveries.
Yes, he certainly has.
After his certificate of compliance
Yes.
has been well
You
done,
tell
the
him.
ink is well dry.
You tell him.
We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions, if we can. And I want to make sure that we're not conflating two separate issues. One is the information that ARCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports.
Yeah, okay, fair.
The federal disclosures. Both
Yeah.
sides have had those.
All right, so you have everything.
Any disadvantage in the first trial, and certainly
Right.
nobody's at a
No one
disadvantage
has.
in this trial.
Everyone has the same information.
We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely been lifted. And we're moving forward as expeditiously as we possibly can.
Yeah. Everyone had access to the same information. Okay, Brendan, you want to whine some more?
Rather than addressing their obligations, it's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judd Welcher's PowerPoint were by exclusion. Attorney Alisi had concerns about
That is the
certain
least
things in
of the
report,
problems we're
so we
talking
took
about,
things
Brennan.
out of the report.
We're talking about new video and new everything.
Provided it in November, then you're saying?
Come on.
Pardon me. We provided his CV in November, and then we provided on our discovery deadlines January 31st, 2025, and then on February 5th, we provided all of the detailed background notes, references, and so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
According to Mr. Alessi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCA. That's when we received permission to engage ARCA. That's when we provided the individuals at ARCA with everything that we had been provided just the month earlier.
Right.
So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
Yeah.
Right. Thank you.
What do you think, Bev?
I think is the only thing left the motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes, where do we stand with that? I thought that you were going to,
We've had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings, the administrative body's rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
It's not just an
The defense
opinion.
vehemently disagrees with that
Yeah.
assertion. That's not the state of the law.
It's
We did provide notice
not an
to the
opinion.
Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything. I
bet
would
they
like
are.
to be heard on that, Your Honor.
all right, so I don't have a copy of what it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of,
Excuse me?
we need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right, get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know, what I need is, I wasn't expecting this here today, so what I need is the paper number. I think it's the Commonwealth's motion to exclude, but the last I had it as, it wasn't under advisement. You were going to figure out what the objection was and what you wanted to put in. All right, so we need to take a recess
I bet we do.
anyway, so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess? And Ms. Little, if you can provide just the paper number on what the Commonwealth's response was.
It's paper number 588.
All right. So Jim, I need that.
All rise for the court, please.
Okay, exciting. So unsurprisingly, the defense would like to be able to offer the entirety of the report relating to Proctor and his friends being disciplined relating to this wonderful investigation. And they'd also like, of course, to be able to offer the ultimate conclusion of that, which was he has kicked off the force. And Brendan over here is like, this is an opinion of a third party. I'm like, no, I don't think it is. I think it's a legal conclusion by the competent legal authority in this context, which is the executive branch in this context. But they were the one that disciplined him and made a finding that has legal impact. So it's not just like we think it, for reasons. They actually, like, there was due process. Again, what due process looks like is not necessarily the same in every case, but Proctor was entitled to due process. He was entitled to a notice and hearing. He got it. He was entitled to offer evidence, I'm quite sure. And they went through a process and concluded that, he did a bad, and also that he should be dishonorably discharged as a result of all those things. But that is a legal conclusion by that, which has legal operative effect. Namely, he's no longer an officer. That's one of the reasons it's a legal conclusion. It has legal impact. It's a legal conclusion by an executive agency, but that's okay. We can do that. Executive agencies do legal conclusions too. It's not necessarily just the courts that do things. They do things that have legal impact, perhaps is the better way of putting it. They have administrative judges. The federal government has administrative judges. We talk about it in deportation hearings, for example. These things have legal impact. And whether or not those things can be reviewed down the line is a whole other set of problems. But to call it just an opinion by a third party is one hell of characterization. It's like, no, it's not just an opinion. It is a legal finding after due process, notice, hearing, blah, 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 blah. And so unsurprisingly, the defense would like to be able to offer this evidence. Not only the actual things that were found, of course, but also the ultimate conclusion, namely that you're very, very bad and you're no longer an officer. And unsurprisingly, of course, the Commonwealth would prefer very much not to have that. I mean, I knew they were going to do that. You knew they were going to do that. I'm surprised that they're conceding to allowing any of it, to be honest. But they're apparently conceding to allowing the findings, just not the conclusion. Which, okay. I mean, all right. So anyways, they're going to have a debate over that for a while as to whether or not that's relevant. But it's not just character evidence. It goes to the heart of the thing. It's relating to this trial. It's on point too. It's even worse than that. Not only is it like that he's dishonorably discharged, but he was dishonorably discharged for things that he did in this trial specifically, with the searching of the nudes and everything. So it's pretty on point because it relates to his conduct in this case. So there's that. So I don't think the Commonwealth's argument makes sense, but she's going to go debate it for a while and, have a discussion about how much of the report they're allowed to refer to, bring in, discuss, and so forth and so on. So exciting. That's going to go with that. All right, so all that good stuff. And then also they're going to review a video that the Commonwealth wants to bring in towards their opening. So they're going to review this video that they want to use as part of their opening argument, which I object to stylistically. But they're going to have a discussion about that for a while for some reason. Yeah. Yeah, it was the police body. It ultimately was the commissioner of police. So it was ultimately the commissioner of police that made the decision in response to a process and a hearing and all the rest of it. So, yeah. And again, Proctor can appeal that. He can take it to court. Good effing luck. Right? Because assuming that they followed the process that was due, and I'm going to assume they did, he's not going to be able to get it overturned. But he's entitled to try if they didn't give him due process, but good luck on that. So, yeah. We should call the commissioner of police as a witness, though. That'd be great. That'd be the thing I'd want to do as the defense, call the commissioner of police if I can. Probably wouldn't be able to do it for a bunch of reasons, but I'd think about trying. Yeah. Thank you. I appreciate the hat too. The hat makes me happy. Yeah, and Proctor, how do you not call Proctor to the stand if you're the Commonwealth? He's the lead investigator. How do you not call him? I suppose you could try not calling him. That'd be interesting. But then the defense probably calls him as a witness just to embarrass the shit out of him. So as the Commonwealth, you almost have to call Proctor, because if you don't, the defense probably will, and you want to always draw the sting. If there's bad information, you want to get out in front of it. You want to be the one to introduce the bad information. So I don't know how the Commonwealth doesn't call Proctor, despite the fact of all the problems, because they want the ability to present, you know, the bad in the best possible light. You don't want to give the other side control. And if you do call Proctor, how does that not just kill your case is beyond me. But then again, a lot of things are beyond me when it comes to this case, as we've previously discussed. I still don't know how 8 members of the jury apparently were ready to convict on some version of manslaughter based on the evidence that's available. I don't know how they thought that, but whatever. Yeah, how they still call him Trooper? I'd object to calling him Trooper when he's called to the stand. I'd object to calling him Trooper. It's Mr. Proctor, if you don't mind. And I'm definitely going to ask why he's called Mr. Proctor. You better bet your ass. But I would object to him being called Trooper Proctor when he's being called to the stand. That's not his name. That's not his name. That's not his name. Dude McGuy for $5 says, this case made me scared of jury trials. Juries are unpredictable things, my friend. Andrew Brankus says 10%. I say even 5%. There's a 5% chance the jury will convict you just because you're sitting at the defense table. Andrew says 10%. Either way, right? Either way. Yeah, there's a 5 to 10% chance they will convict you just because you're sitting in there. That is the baseline minimum. Basically, no matter what the Commonwealth does, there's at least a 1 in 20 chance they'll convict you just because you're sitting at the defense table. Yeah. So better not roll that nat 1. You know what I mean? Yeah. If not guilty, why guilty shaped? Exactly. Exactly. I mean, after all, a cop is dead. A cop is dead. Someone's got to be punished for it. We can't let them get away with murder. This person's convenient. You know, can't let her get away with murder. Let's convict her. Yeah, no doubt. 100%. And we know that's to be true because we had 8 members of the jury, apparently some of whom were saying John O'Keefe was there, Karen Reed was there, therefore Karen Reed did it. And I'm thinking to myself, you know, we need several other steps in between those two things. But apparently John O'Keefe was there, Karen Reed was there, therefore Karen Reed did it was persuasive to some of the members of the jury, apparently. Yeah. Yeah, if not guilty, why were they charged? No smoke without fire, etc., and so forth. All those things. All those things. Would I choose trial by jury or trial by judge if I were a defendant? I don't know. Probably trial by jury. But it would depend on the particulars. But probably trial by jury. You know? It would depend. If I think my gut instinct is if I had a really technical defense, then I would want to judge. And also if it was a very emotional prosecution, but also a little thin, I might want to judge. So if I was being charged with something that had a huge emotional impact, but maybe the evidence against me was a little thin, then I might prefer a judge on the basis that, you know, that the horror show might be more persuasive to a jury. But I don't know. I'd have to really think about it, obviously, if it were really me for real. And same, incidentally, if I were representing someone, although my experience is not in criminal law, but if I were representing someone, same, I'd have to think about it. But probably a jury would be probably the way to go, despite its problems. And then it just becomes an issue of trying to select the right jury and hoping for the best. There is a document in staff chat. Excellent. What do we got in staff chat? There's a decision from a court. Exciting. Relating to what? JGG on Donald Trump. Okay. So we can discuss that. We can discuss that on a later issue. Yep. Blah, 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 blah. It looks like the district court is holding the government in contempt relating to JGG. So, yeah. That's exciting. We'll definitely be covering that later. JGG, by the way, for those of you who are unfamiliar, was an illegal immigrant arrested inside the United States and deported to El Salvador. However, he had previously been adjudicated as deportable, but there was a stay on it that precluded him from being deported to El Salvador. He could have been deported somewhere else, but he couldn't have been deported to El Salvador. And that's exactly what the administration did. And so this went to the U.S. Supreme Court, and the U.S. Supreme Court was pretty pissed. And they've been dicking around on this in the lower court level, as one does. And it looks like now the judge is holding the administration in contempt. So things are escalating as they were probably going to do. So that is where we're at. Yep, we're doing a contempt thing. We're holding the government in contempt. That's going to be exciting and fun. Yeah, probable cause to constitute contempt. And if not, then refer for prosecution. But of course, the government won't prosecute. But, you know, well, that's strictly speaking not true. In a contempt proceeding, the judge can actually appoint counsel to prosecute. It's one of the few exceptions to the rule because the judge has inherent authority in contempt. So the judge could theoretically appoint this to someone outside DOJ to prosecute the contempt. So things are getting spicy. Spicy. So we will discuss that at a later time in more detail. And I look forward to more people telling me that, you know, I don't know what I'm talking about, as per always. That's fine. Do I think there's too much authority in district judges' ability to negate executive actions? I have problems with universal injunctions, but this isn't a universal injunction. This is just dealing with one guy's case. So my issues with universal injunctions are not implied by this case because this is just a guy. And so do I have a problem with the district court issuing an order relating to a guy? Not really, no. And of course, cases start in the district court. That's where they're supposed to start. That's what we do. So I have no problem with the district court in the first instance doing this. Now, whether or not I have a problem in this particular case, whether or not I think the judge is wrong is an issue that I still have to be decided, right? I don't know whether or not the judge is right. I'll have to read their decision, but I don't have a problem with it in principle. So that's fine. Was I okay on Ruckles Live? Did I look a little down? I was a little down. It's one of the reasons I wanted to join the live, because I was I was feeling depressed. And so I wanted to be with somebody that, that's one of the reasons I wanted to join the live, because I was down. And as to that, I deal with depression. We've talked about that many times. And sometimes you're just on the wrong end of the bell curve. And so, it was what it was. And then I had a very unpopular opinion, and people didn't really understand my opinion, or people's reaction to it was very visceral, which was a bit annoying, because we were dealing with this case in Canada wherein one lawyer sent the other lawyer in the case a intimate image of somebody, I think the client or something like that. I'm not quite sure. But the one lawyer sent the other lawyer in the case an intimate image. And the Canadian court came down on the lawyer really hard and basically said that what they did was unethical. And I said, I don't think I agree with this. I don't think I agree with it. And of course, people in chat were saying, well, don't you see a moral problem? Don't you see issues, with sending nudes? Like, why do you think that this is, sending nudes is bad and all the rest of it? But of course, in my own head, I'm thinking about this as a rule, because it's a rule, right? And I'm thinking to myself, okay, there might be some problems with this. And so then I tried to offer some suggestions about why this might be a problem. Like, let's suppose I have this case, or let's suppose I have this case. And then people in chat were like, but it's not this case. And I'm like, yes, but the problem is it's a rule. And so I'm trying to show you why the rule doesn't work, right? I'm showing you by other examples why my sending of an intimate image to another lawyer in a case might be not only proper, but might be like a very good thing to do. It might be a perfectly appropriate thing for me to do. It isn't to say that it's always appropriate. That wasn't the argument I was trying to make. I was just trying to make an argument that having a rule that categorically bars it is an issue, because it might be in the furtherance of my client's interests to share this image for any number of reasons that we could dream up if we're trying to dream up a scenario, right? If we're trying to dream up, why would this intimate image be relevant to some case? I mean, you can dream up a scenario why it would be relevant. Maybe the image, maybe there's a picture, maybe in the background of the picture there's a clock that shows the time. Maybe it's alibi, or maybe it's counter alibi, or maybe it's like, oh, I was attacked by this person. No, you weren't. You were with this other person. Or maybe the image is showing a bruise that reflects an injury. Or maybe it's not maybe it doesn't show a bruise because the person is saying there was an injury. I'm like, nope, here's a picture, shows there was no injury, right? So it's like, if you're trying to dream up scenarios why this intimate image would be relevant, it's like, you can dream up scenarios. And then you can dream up scenarios why me as a lawyer, it might be a good idea for me to share this image. It furthers my client's case. It undermines your case, or whatever, right? So it's like having the categorical rule is a problem, because I can dream up scenarios where this might be a good thing. This might be prudent. And so it's like, I don't necessarily agree with the rule, because it seems like it's imposing on me a barrier to preventing me from presenting potentially relevant material and necessary evidence. And again, like, there might be reasons to do this very early in a case. Like, can I dream up a scenario where it's like, yeah, you could do it later. It's like, maybe I could do it later, but maybe there's a reason for me to do it right now, right? It's like, okay, I got the complaint, I've been served, but I have this image, and it happens to be an intimate image, but the intimate image basically proves my case. Somehow, some way, the image proves my case. And so, like, I go to the other attorney and be like, I know you sent me a lawsuit and all, but, look at this photograph. Basically, completely undermines your case. Would you like to withdraw now so that we can save ourselves some time? Right? So, like, there might be reasons to do this. And so having the rule seems problematic. And so that's what I was thinking. But of course, the chat was like, well, don't you see the moral problem in sending nudes or intimate images? Don't you see, like, why are you dying on this hill? One person said, no wonder Uncivil isn't married. What the fuck? Like, no wonder Uncivil is not married. What the fuck? What are you talking about? Like, what the fuck kind of argument is this? Right? I was like, there might be very practical, very reasonable reasons that I as a lawyer might want to / even need to do this. And this is why I'm not married, because I'm conjuring possibilities about why this rule might be a problem. What the fuck? Right? What the fuck? Right? So it's like, I don't, all the rest of it. So, but I can't have this conversation apparently, because me apparently positing the possibility that a lawyer might want to send another lawyer an intimate image of somebody for a perfectly legitimate legal purpose that is in furtherance of the interest of the client. Apparently that possibility is like too far gone or something. So I was like, okay, I don't know what to do with this, but I had some haters in chat, and then I felt bad about it because I don't like being called immoral. No one likes to be called immoral. I don't like saying this is the reason Uncivil's single or this is the reason Uncivil's not married. That's not nice. That hurts me. I don't like that. I mean, I would like to point out, of course, those arguments don't actually address my argument in any way. They don't actually address the substance of my argument. This is the reason Uncivil's not married actually is not a logical rebuttal, but, I digress. And also, incidentally, by the way, I could be wrong. It was just a gut reaction opinion. It was a gut reaction opinion. It's like, okay, here's the rule. It's like, okay, I think this might be a problem. I'm not sure I agree with this. I'm not sure that I agree that the lawyer did anything wrong. I'm not sure that this rule is a good rule. It sounds to me like it might be a problem. Now, maybe it's the case that if you walked me fully through it, maybe it would be the case that I'd be like, oh, okay, I understand now. So, maybe it makes sense in the end, but it didn't make sense to me immediately. So I'm like, I can see problems. And maybe it's like, oh, the problem isn't that he sent the nude image. The problem is he didn't do it, by, obtaining some sort of non-dissemination order or something. Maybe that was the problem. It's like, oh, okay. It's like, I understand that, right? Maybe there was a procedural mechanism that he didn't go through. He was supposed to only share the intimate images in this way, not this way. And so that's the problem. There was another mechanism for him to do it, and he followed the wrong mechanism that didn't provide enough security for the image. I'd be like, oh, okay, that makes more sense. But that wasn't the way I read it, the way it was being explained to me. It wasn't like he didn't do the right procedure. The problem was apparently he did it at all. And I'm like, I don't know if I agree with that. So I was trying to proffer that case, and some of the chat was not having it. So it's exciting. It could be the fact I argue in a particular manner that's an obstacle to marriage. Well, I don't necessarily understand that either, to be honest. It's like, I am who I am, to be honest, and I'm not necessarily everyone's cup of tea, to be sure, but I'd like to think that there's somebody for me. And so some people may not like the way I think, but it is the way I think. And so there's that. And the way I argue, I'd like to think, is very logical and reasoned. It's like I always try to look at things in a very reasoned, logical way. And it's like, okay, you're making this argument. Let me try to work through that in a reasoned, logical way and try to say like why I agree or why I disagree or express my opinion or thoughts. And then, theoretically, we would have a discussion where, then you would respond to me and perhaps we get closer. But like, if that fundamentally is what's keeping me single, the fact that I try to like look at things in a reasoned, logic way and try to be like, well, that's not true. I don't agree with that. I don't understand that. Is the problem that's barring me from marriage is that if my wife said something, I might disagree with her? Or I don't quite understand it. But maybe the fact I don't understand it is what's keeping me single. I don't know.
Session, you may be seated.
I don't know.
All right, so the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
No objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay,
That's the audio, but there will be the visual with it that was aired.
okay. I was able to see the video.
Super.
Okay.
Work.
All right, were you as well, Ms. Little?
Yes, we were able to see the video, and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss that. I'm not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two to discuss with the
Sure.
Commonwealth, if there's a remaining issue, we can address that promptly with the court.
Okay, can we address, is it something you need for your opening?
It's not.
Okay, all right, so yes, we'll address it sometime next Tuesday or Wednesday. Take your time in working it out, all right?
Thank you.
Okay, so now is the only thing left the motion that Mr. Bradle's here for?
As far as I know.
Okay. All right. Morning, Mr. Bradle.
All right, let's hear from Turtle Boy's lawyer.
Okay. So, Jim, you have that. All right, I probably have it here too. I have one, Jim, thanks. All right, I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradle. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important. The one in case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right, now I'll hear you, Mr. Bradle.
All right, thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court.
I love the fact that Court TV actually just labels him as Turtle Boy's attorney. That's hilarious to me. They don't call him Kearney's attorney. They call him Turtle Boy's attorney. Epic.
Where it's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
I bet he
Can I
is.
just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on,
So the answer is yes. I'm sorry. The answer is yes, Judge.
okay? So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first.
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
Oh, I'm
said-
sorry.
But that's okay. I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before. The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let Mr. Brennan speak, and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for...
Wow, I'm surprised he actually is saying that. I expected him to go harder in the paint. That's amazing. I didn't expect him to do it. I expected him to say something like, we can ask questions that would only relate to his conversations with Karen Reed. We would only ask questions relating to his witness, and we wouldn't ask questions that would incriminate him. Or even we could go one step further, because you're the prosecutor, we'll give him use and derivative use immunity for anything he says on the stand. That would solve the problem. So I'm surprised that he's not doing either of those things. It's like, I'm either going to narrow it down, or I'll just give him use and derivative use immunity, and then I can call him anyway. He's not doing either of those things. That's amazing to me. Wow. Okay. Interesting. Interesting way to go. I'm surprised.
Sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But as a predicate, he would need to assert his fifth.
Do you need that to be done formally, or do
Yes.
you want it to be done formally?
I do.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
We'd reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
Okay. Do you want to call him now and do that now, Mr. Bradel, or not? Do you want to talk with your client? And
Have a minute to talk.
sure.
Are we going to have Turtle Boy take the stand here? Excellent. I wonder if he's doing this for a reason that is not necessarily clear. I wonder if he's doing this because he can force it by giving immunity or something. I wonder if he has something in his back pocket he's not saying. Is Kearney walking into some sort of trap right now? I don't know. Let's find out. Could be fun.
Why don't you know what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Everybody stay. All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the
Oh
pledge.
man, this is great. This is great. Yeah. So why can't he assert it on his behalf? I don't know. I'm wondering if there's a technical reason we're doing it this way. Because he's the prosecutor, so he can offer use and derivative use immunity. So I'm wondering if he's asking him to formally take the fifth so that he can nip it in the bud. I wonder if there's a procedural reason he's doing this. Or because he takes I wonder if there's, because he takes the fifth, somehow, in some way, it benefits the prosecutor in a way I can't quite figure out. Because otherwise, why not take the representation? Why actually just have him take the stand? Why are you actually doing that? On the hope he'll slip up? Is that why you want him to take the stand? On the hope he'll say it? I don't know. Yeah, so I don't know. But that's where we're at. So interesting. The civil suit? No, it doesn't impact the civil suit, because whether or not he takes the fifth in the civil suit is a separate question, separate and apart from this. So it shouldn't impact the civil suit unto itself. But it's not that. Yeah, I saw that. I saw Turtle Boy was laughing in the back. I saw him laughing. Yeah. It's like, what exactly is up? Can the prosecutor say he takes the fifth in another case? Because you're talking about taking the fifth in your case, but there's nothing saying he'll assert another case. Right. Yeah, the fifth is obviously his right. He is under no obligation to take it in any particular case. And just because he takes the fifth here doesn't require him to take the fifth in any other context. Yeah, so it doesn't bind him. He could take the fifth in his own case or not. He could take the fifth in the civil case or not. It's his right. So yeah, there's no problem there. I mean, once he gives it up, he might lose it indefinitely. So it's not necessarily true the other way around. Once you testify, you might not necessarily have the fifth in another context. But if you take the fifth, you can waive it in a different context. You can do it that way around. So that's true. Brennan's just being a bitch. It might be Brennan's just being a bitch and making him do it itself because he's just a bitch. But we get to see some Turtle Boy action, and that's exciting and fun. Why would Turtle Boy take the fifth? He's being prosecuted for witness intimidation. And so hypothetically, he could say something that would prejudice him in his own criminal case. That's why. You know, the conversations he had with witnesses could potentially inculpate him relating to his own witness intimidation case. As the defense notes, the case is kind of bullshit based on what I've seen. I haven't seen a lot of it. I haven't really dived deep into it. I've been trying to keep myself out of the Turtle Boy lore. I'm already deep enough into the Karen Reed lore. I don't need to go also into Turtle Boy lore land. But based on what limited I've seen so far, it seems like it's pretty bullshit. So, you know, there's that. I think my browser just crashed. Hold on, I'll just refresh it because I'm not getting... Oh, okay. One moment, please. Can't see your chats. It's very disappointing. I plead the fifth. I plead the fifth. 1, 2, 3, 4, fifth. Anything you say, I say fifth. Go ahead and ask me a question. Fifth. Fifth. Yeah, I can't trip him up if every word out of the mouth is I plead the fifth. Yeah, other than his name, right? Other than his name. Any question should be I plead the fifth, right? Yeah. I think the only reason he's doing there's some sort of procedural reason he's doing it. But yeah, use and derivative use immunity would solve the problem. And then they could still prosecute Turtle Boy. So, you know, no prejudice to them. They just wouldn't be able to use any statement he made in court against him. So maybe it's a prelude for that. That's the only thing that makes sense to me. Assuming he wants to call Turtle Boy to the stand. You know, and also he could offer use and derivative use immunity and then just not call him to the stand. If his goal is to keep him out of the courtroom, then be like, okay, I'm giving you use and derivative use immunity. Now you can't refuse to testify, but I'm not actually going to testify you to actually going to call you, but I'm not going to tell you that part. And so then the immunity is meaningless. So, you know, maybe it's part of some scheme. I don't know. There's a scheme in here somewhere. There's a scheme. I can smell it. Smells like bullshit.
You are unmuted.
All right, what you got?
Court is back in session. You may be seated.
All right, Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment right?
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay. All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the representation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Oh, sure. Is there any objection for everybody hearing this?
There is. I would like Mr. Kearney to assert his Fifth. I
Oh,
want to make the record.
I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradel. And
you.
all recording devices are off.
Thank you.
FTR goes to sealed, Tory, and Chrissy.
Okay, so we're going to have Turtle Boy testify at sidebar. I'm disappointed. You're disappointed. We don't get to hear some Turtle Boy. I'm very disappointed. We don't get to see the dramatic moment of him take the stand, be like, I plead the Fifth. Very, very disappointing. I am teased and very sad. Oh, well. Can't always get what you want all the time. I still feel like there's a game afoot, though. But the judge's question was right. It's like, because he can only plead the Fifth with respect to things that would incriminate him. So hypothetically, the prosecutor could theoretically ask questions that would not incriminate him that he'd be required to answer. But the prosecution says, we don't think we can do it, which is fair enough, right? So they think that they can't do it. So they're not willing to try to stay within that bounds.
Tory, Jim?
Yes.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims. We also would like to have the court consider the two minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary
sure.
on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them.
Apparently, turtles have Fifth
All right,
Amendment
this
rights,
looks
too.
You all made some progress in a way that where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay. Anything else today?
The only thing I would ask the court to consider is, with regard to the speaker, the reader issue,
Oh, okay.
if the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy
And it is something that we've done.
right, understood. I would like to see I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing. That's all.
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
Okay. All right. Thank you all. We'll see you Tuesday.
Thank you.
All right, so the court, please.
All right, my friends, that we won't tune out just yet. First of all, we might get some mic audio, and we also get fan. Thank you for watching Core TV. Well, thank you, Core TV, for actually having audio. That was nice. And thank you for bringing us hot, spinny fan action. We will enjoy hot, spinny fan action for a while. Spinny fan goes round and round. Spinny fan never fails. Spinny fan is the best fan for us all. Was there a decision on ARCA? Not really, no. I think Spinny fan has stopped spinning. I think the stream is over. Oh well. Well, we have static fan. Static fan doesn't spin. Static fan just sits there. Yes, that's not as good a song. But that brings us to the end of today's hearing. So yeah, no particular decision relating to ARCA or any other issue relating to this. I don't even really understand what the issue is, to be honest, with ARCA, except that they're just whiny and complaining and all the rest of it. So there's that. But yeah, it's just kind of is what it is. So all that good stuff. Yeah, I don't know. I don't quite know what the Commonwealth was at by forcing Kearney to go up there and actually say it, but there must be a reason somehow, some way. Are we doing the document in another stream? 100%. We're not going to do it in this stream. It's totally separate and apart from this. So 100% we're going to do it in a different stream. Probably after I get some lunch, and maybe after I go to the art store. I think I'm going to do a run to the art store and get that film and do some arts and crafts and see if I can fix some of these glare issues. I think that's what I'm going to do. Do they agree he would not take the stand at all? In this case, yes. And so at the moment, he is allowed to attend the trial, except for witnesses in his own case, which, whatever. So, yeah. So all that good stuff. Yeah, the milestone chat thing, I'm not sure what that's all about with the milestone chats, not allowing you to type things. I'm not sure what that's due to. If I had to guess, it's because it's 99 cents. I think is the issue. I'm not sure YouTube allows milestone chats for 99-cent chat level. So you might have to join at a higher membership tier to have a milestone chat, but it's not due to any setting on my end. The milestone chats are enabled on my end, and I haven't done anything to disable them for 99-cent members. So I don't know what it's due to, but yeah. So if I want milestone chats, I might have to increase the price to $1.99. So yeah, which I know is not necessarily ideal, but it is what it is. Just Rhonda has been a member for 3 months. Thanks. Is a paid super chat? Oh. Just Rhonda's a member for 3 months. Jennifer is a member for 16 months. Michael Stenson's been a member for 21 months. I read Dude McGuy's chat. I read Tracy Walker's chat. Dennis Carnes gave $2. I read you get Kling film for your window. I have it for your bathroom window. Trying to find the right film has been the problem, but thank you. Stingy Jennifer became an uncivilian. Tracy Walker gifted 50 gift memberships. Then she gifted different 50 memberships. Can we expect commentary on Trump refusing to bring back the man from El Salvador? Probably later today, because we're going to do the contempt thing. So we'll get something on that. We're all mad here, member for 6 months. Unbalanced equation member for 5 months. Doom Guy became an uncivilian, and those are all the super chats that came in today. Yeah, I'm not sure what the no text for the milestone chats is about. Yeah, I think it must be because it's 99 cents. That's the only thing that makes sense, because you can't super chat for $1, right? Well, you can't type a message in a super chat. So you can send a $1 super chat, but you can't type a message. $2 is the least that lets you type a message. So the only thing that makes sense is because my memberships are 99 cents, it treats it like a super chat, and therefore you can't type a message. That's the only thing that makes sense. And so the only way to solve that problem is to increase the membership tier to $2, which I don't know that I necessarily want to do that, but I could. But I want to keep it as cheap as possible. So I guess then we're just stuck with where we are. Anti-glare is polarized. That's what you want? Polarized film? Well, polarized film might fix it. So yeah. So I need like a polarized film. Polarized film sheet. Yeah, makes sense. So I need a large polarized film sheet. Here's one that's 12 by 17 for $35. Polarized filters used for experiments involving light. So yeah, I could put a polarized film sheet up on there. You put some TV film sheets on chat for me? Oh, okay. I saw the one you sent me earlier. Yeah, I saw the one from the anti-glare film from Texas Art. I saw that chat earlier. Ari had specific questions about the Fifth Amendment. Oh, okay. I'll be happy to call him. Will I make woman-style beefish watches? Eventually, yes, I will. So yeah, I don't see anything in the Discord, and you're not allowed to post links to YouTube. Yeah. Polarized film. Yeah, none of these polarized sheets are big enough. Yeah, so I think my best bet might be with the one from the Texas Art thing that you guys sent me earlier. Yeah. High clarity general purpose film is perfect for commercial art applications. Film is industry standard for overlays, color separation, available matte and clear. It's preferred when glare is a problem. Certified as biodegradable. I can get myself 25 inches by 100 feet for $86. I think it might be the way to go. Can I explain the contempt for the Trump administration? I'll do it in a later video. I'm not going to do it now. We'll go through it. Should I call RA? See if he picks up? Let's call RA. Let's call Recovery Addict. Let's see if he picks up.
Hello. Please state your name after the tone, and Google Voice will try to connect you.
Uncivil law. Is that lunch? Oh, well. Let's see if he picks up anyway.
Hey, Kurt. How's it going?
Hey, man, I just wanted to let you know I'm streaming. I heard that you had a question on Fifth Amendment issues.
I did. As far as what specifically why it's a problem for someone to be called to the stand and take the fifth. Is it just apply for juries or?
Well, yeah, no, it's mainly for juries, but the problem is that, you know, obviously you have the right to remain silent, and that fact that you remain silent can't be used against you. So the concern is by actually going through the formality of calling someone to the stand, especially in front of the jury, and having them say, I take the fifth, that the jury is going to be insulted, you know, basically they're going to be offended by having it taken in front of them, and the jury instruction will not be sufficient to cure the problem. So it's like, well, why even bother, right? So that, you know, we don't have the scene of this guy, you know, taking the stand and taking the fifth, and then the jury hates them because, well, the jury wants to know. The jury wants to know things. Juries don't like it when they don't know things, and so they're going to hold it against them, which is the very thing they're not allowed to do. That's why.
Yeah, and so a judge could look at this and outside the presence of the jury, make a determination that there's an area of questioning where there's no right to plead the fifth.
Yeah, correct.
And could allow partial.
Yes, correct. So the judge basically was asking that question, like, do you think, was asking, you know, at least in principle, it's possible to constrain the questions so that your Fifth Amendment right wouldn't be implicated. And the judge basically is asking that. It's like, do you think you can do that? And the prosecutor's answer in this particular question was, no, I don't think I can do it, because I think necessarily I would have to get into things relating to his witness intimidation case. I don't think I'd be able to stay outside the bounds. So therefore, there's no point in holding the hearing, because yes, in principle, we could hold a hearing so that we only ask questions that the Fifth Amendment don't apply to, but the prosecutor says they can't do it. The thing that I'm trying to wonder about is if there's a reason, as a matter of procedure, that the prosecutor actually wanted Aiden to actually say it himself. Like, is there a reason for him to do it? And like, the only thing I can think of, like procedurally, is that somehow it's necessary in Massachusetts for Brennan to turn around and grant use and derivative use immunity, which would then allow him to kick him out of the courtroom again. But he didn't say that right away, right? He didn't say right away, like, oh, I'll just grant use and derivative use immunity. So like, the only thing I can think of is that by forcing him to actually say it, that somehow it gives him an option to somehow do it. Because otherwise, I don't know what the point of him forcing him to say it.
You know, the optics live on TV type thing.
But, yeah, well, it's like, and the judge didn't even call him up to the stand to do it. They did it at sidebar, which there's no jury here. So, it wouldn't necessarily have been a problem for the judge to do it here, but she didn't even go with that. So we didn't even get the optics. So I don't know what the point was.
Yeah, interesting. Kurt, I'm a smarter man today because of you. Thank you very much.
Yeah, no problem. I'm here to help. Talk to you later. Bye-bye.
Right. See you. Bye.
Bye. See, I'm here to help everyone's questions. I help clarify for everybody. So all that good stuff. Bev is leading the prosecutor on how to prosecute. Of the prosecutor's many sins, or the judge's many sins, I didn't think that was a problem. I don't know if that was just for the point of clarification about exactly what he was asking for. Right? What exactly are you asking for? Or what exactly is the issue? So I don't know if that was meant as just a probing question or meant to like goad him. So of the judge's many sins, I guess I'll give her a pass on that one, which I know is generous, but I'm in a generous mood, I guess. So that's fine. A sound clip for local Boston news. Yeah, maybe that was what it was. Maybe it's maybe it was no more complicated than that. Maybe he was really hoping that Turtle Boy would be put on the stand and have him, say, well, I plead the fifth for the sound clip. Maybe that's what he was hoping for. And he didn't even get that. Lame. So yeah, that's a perfectly reasonable thing. He was just hoping for the clip. So, you know, it would be good for the news and a little bit of embarrassment, help him lose a little face. And he didn't even get that. How sad for him. How very sad. So, all right, I'm going to go ahead and sign off for now. I'm going to, I think, go to the art store and see whether or not this film is the answer to all my problems. And if it is the answer to all my problems, I am going to buy it and then fix my things behind me. And then I'll do a stream later today and all that good stuff. So, yeah. I'm going to just print this page. Need to make it a little smaller so it fits on the page. There we go. Excellent. Print page 1. Current page. Great. All right, guys. I will see you at some point later today. Until later, I've been Uncivil Law. I hope you have a great one. For cheers from now, my friends, and goodbye. I'll dump you over to Melanie's chat too, because I'm nice. Hold on. Where is she? I know she's still streaming. There's no way she's not streaming. There she is. All right. I'll dump you over to Melanie's chat. Have a good one, guys. See you in a bit. Later. Bye.